friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. And if you have seen my previous videos, I have already discussed the Haryana, Uttarakhand, Rajasthan, and currently we are doing the series of Delhi Judiciary, and Delhi Judiciary का paper अब just आने ही वाला है. And in this sequence, what we have done, we have already discussed all the papers from 2010 to 2019. Now what we are doing, actually we are just giving you the all the questions which have come from 2010 to 2019 in the exam of DJS for every particular subject. And in today's video we are going to discuss the all the questions of Evidence Act which have come in examination of DJS from 2010 to 2019. सो फ्रेंड्स, इफ़ यू आर न्यू ऑन दिस चैनल, आई वुड लाइक टू रिकमेंड कि आप फटाफट से इस चैनल को सब्सक्राइब कर लीजिए एंड सब्सक्राइब करते टाइम बेल आइकन को जरूर प्रेस कीजिएगा. सो फ्रेंड्स, चलिए करते हैं अब एविडेंस एक्ट.
Question 121. Mark the correct statement. Evidence excluded by the Evidence Act is inadmissible even if it seems essential for the ascertainment of the truth. Parties cannot contract themselves out of the provisions of the Act. A court cannot, on the ground of public policy, exclude evidence relevant under this Act. Or option D, all of the above. This is the general principles question and the right answer should be all of the above. Option D is the correct answer. Question 122. A is accused of a child's murder. The following facts are constructed in the case. An hour before the murder, A went to the place of murder with the child. A alone returned home. Collar of A's shirt found to be blood stained. The evidence which takes into account the above mentioned facts is called direct evidence, circumstantial evidence, real evidence or secondary evidence. It is circumstantial evidence. Okay. Question number 123. Mark the incorrect statement. The terms relevancy and admissibility are coextensive or interchangeable terms. All admissible evidence is usually relevant, but all relevant evidence is not admissible. Relevancy is the genus of which admissibility is the species. Relevancy and admissibility are neither synonyms nor is the one included in the other. Incorrect statement is statement 1. A is the incorrect statement because they are not coextensive. Come to question number 124. The question is whether A owes B rupees 10,000. The facts that A asked C to lend him money and D said to C in A's presence and hearing, I advise you not to trust A for he owes B rupees 10,000 and that A went away without making any answer is a relevant fact, irrelevant fact, fact in issue, or none of the above. It is a relevant fact. Option A is the correct answer. And it is illustration G of section 8 of Evidence Act. Question 125. A and B were prosecuted for conspiracy for bribing a police officer. A came to the police station and offered an inspector packet of currency notes. He told the inspector that B had sent the money as consideration for hushing up the case against him. The offer of money and the accompanying statement made by A were relevant against A only, B only, both A and B, and none of the above. It is a conceptual question basically and it is related to a case. Case name is Badri Rai versus State of Bihar and the right answer should be both A and B. Question 126. Admissions by agents. Always admissible in civil proceedings. Admissible in civil proceedings only if the agent has authority to take admissions. Not admissible in criminal proceedings. And both B and C. Admissions by agents is section 18 of Evidence Act and right answer should be both B and C. Option D is the correct answer. Question 127. Telling his wife that P's wife had called him to receive payments due to him, K leaves his house. After 2 days, his dismembered body is found in a trunk. In P's trial for the murder of K, the statement made by K to his wife is inadmissible, partially admissible, inadmissible as it does not directly relate to K's death, or admissible as it relates to the circumstance of the transaction which resulted in K's death. It is option number D. And this is basically a case which is Pakala Narayan Swamy versus Emperor. Question number 128. If X is charged with Y's murder, which of the following will be the hearsay evidence? Z in his evidence states that I saw X stabbing Y with a knife. Evidence of A that Z told me that he had seen X stabbing Y, both A and B, or none of the above. It is option number B. Evidence of A that Z told me that he has seen X stabbing Y is the hearsay evidence. Now come to question number 129. If on the carbon copies of a letter written on a typewriter, signature have been put on the first letter, then other copies will become what? Will also be primary evidence, which is section 62 Evidence Act, will be secondary evidence, which is section 63 of Evidence Act, will be no evidence, or none of the above. They will become what? Secondary evidence. Option B is the correct answer. Question 130. If no attesting witness can be found, it must be proved that attestation of one attesting witness, at least in his writing, signature of the person executing the document is in the handwriting of that person, both A and B, or none of the above. It is both A and B. Option C. And which section? Section 69 of Evidence Act. Question 131. X sues Y for money due on a bond. The execution of the bond is admitted, but Y says that it was obtained by fraud, which X denies. The burden of proof is on whom? X, Y, the state, or X and Y both? It is on Y. Option A is the correct answer. And it is which section? Burden of proof. Section 102. And this is basically illustration B of that section. Question number 132. In which of the following cases the court may presume under section 114 of Evidence Act that a man in possession of a stolen goods after the theft is either the thief or has received the goods knowing them to be stolen? The first statement is basically illustration A of section 114. And second statement that the judicial and official acts have been regularly performed is illustration E of the same section. And option C that the evidence which could be and is not produced would, if produced, be unfavorable to the person withholding it. Example, the police withholding a piece of evidence. And option D, all of the above. It is option number D, all of the above. Question number 133. Which of the following is an exception to the doctrine of estoppel? Estoppel with section 115 of Evidence Act, where a minor represents fraudulently or otherwise that he is of age and thereby induces another to enter into a contract with him, when true facts are known to both parties, when the representation is against the statute, or all of the above. It is all of the above. Question 134. A intentionally and falsely leads B to believe that certain land belongs to A and thereby induces B to buy and pay for it. The land afterwards becomes the property of A and A seeks to set aside the sale on the ground that at the time of sale he had no title. Option A must not be allowed to prove his want of title. B says that A must be allowed to prove his want of title. C is the court will decide, and none of the above. It is option number A. And which section? Section 115, illustration A. Question 135. A local development authority announced a housing scheme and accepted applications under it. Subsequently, finding that the scheme was in violation of the master plan, cancelled it. Option A. It is free to do so without any shackles of promissory estoppel. It is not free to do so due to promissory estoppel. Option C is it is free to do so without any shackles of promissory estoppel, as there cannot be any estoppel against the government in the exercise of its sovereign, legislative and executive functions. And option D is none of the above. This is basically general principle, and the right answer is option number C. Question 136. Which is the most appropriate definition in relation to the hostile witness? Hostile witness with section 154 of Evidence Act. A hostile witness is option A is one who from the manner in which he gives the evidence shows that he is not desirous of telling the truth to the court. Yes, option A is the correct answer. So no need to read out the other options. Question 137. Confession of a co-accused not required to be on oath and cannot be tested by cross-examination. First statement is no evidence within the meaning of section 3 of Evidence Act and cannot be the foundation of conviction. Statement: the only limited use which can be made of a confession of a co-accused is by way of furnishing an additional reason for believing such other evidences as exists. Statement third is: it is a very weak type of evidence and is much weaker even than the evidence of an approver. In the aforesaid proposition, which one is correct? Statement: only 2 and 3rd is correct. Question number 138. A disputed handwriting can be proved by calling an expert. Disputed handwriting by calling an expert. Which section? Section 47 of Evidence Act. Option B is by examining a person acquainted with the handwriting of the writer of the questioned document by comparison of the two admitted and disputed, and both these statements are related to which section? Section 73 of Evidence Act. And option D, all of the above. Right answer should be what? Option number D, all of the above. Question 139. Cross-examination of a witness must relate to relevant facts and has to be confined to what the witness testified in the examination in chief. And option B is must relate to relevant facts but need not be confined to what the witness testified in examination in chief. Option B is the correct answer to cross-examination of a witness. Now come to question number 140. After re-examination of a witness, the adverse party has right to further cross-examine the witness afresh in general, has no right to further cross-examine the witness. Option C, right to further cross-examine the witness only when a new matter is introduced in the re-examination. Right answer is what? Option C is the right answer. Re-examination of witness, it is mentioned where? Under section 138 of Evidence Act.
Next is question number 155. Circumstantial evidence is considered weak evidence as compared to direct evidence because it has two errors of fallibility. One of fact from which inference is drawn being proved, of the inference to be drawn from the fact proved. आंसर क्या रहेगा इसका? 1. एक conceptual question है. Next is 156. Whoever caused bodily pain, disease, infirmity to any person said to cause hurt. Therefore, use of force is essential. No, it is not essential. Direct physical contact between the accused and victim is essential. No, it is irrelevant that no force was used. देखिए, force is relevant but it is not essential. Essential लिखा है, अगर यहाँ पर लिखा होता relevant तो ये भी ठीक हो जाता. So answer is 3. Next is 157. Whether a weapon is deadly weapon is a question of fact. 2 is the answer. Next is 158. In law of evidence, fact means and includes anything perceived by senses, state of things capable of being perceived, mental condition, all of the above. 4 is the answer. Where it is mentioned? It is mentioned in section 3 of Indian Evidence Act. Interpretations. Next is 159. Only such facts are made relevant by Evidence Act as are encompassed by section 5 to 55. 1 is the answer. ये कहाँ पर लिखा हुआ है? It is mentioned in Indian Evidence Act because relevancy of evidence is in chapter 2 of part 1 and chapter 2 is from 5 to 55. Next is 162. Dying declaration is relevant evidence under 32 notwithstanding being hearsay evidence because if a person is dead and anything said by a person as to cause death is relevant since the dead person cannot be brought to the court to testify. So 2 is the answer. Next is 163. In the writing containing acknowledgement by A that he will sell his house in Kolkata to B for a sum of 50 lakh or 60 lakh. So it means a patent ambiguity. Having blank space with respect to particulars of the house number, street and colony. And it not being disputed that a house on the plot land measuring 300 square and another house on the land and measuring 1000 square yards at Kolkata. Suit filed by B against A. B can lead evidence. None of the above. कोई evidence lead नहीं करेगा because it is a patent ambiguity mentioned in section 93 and it is illustration B. 93 of Indian Evidence Act. Next question number 166. Accused A makes a confession in front of his friend B. When B goes to meet A as A is produced for remand in the court. देखिए जो पुलिस जो है ए को लेके जा रही है कोर्ट में एंड वहाँ पर ये अपने फ्रेंड बी से मिला और उसके सामने कन्फेशन किया तो क्या वो पुलिस की कस्टडी में नहीं है? पुलिस की कस्टडी में है तो क्या होगा? वो inadmissible as since it is made in police custody. So one is the answer. Where it is mentioned in section 26 of Indian Evidence Act. Next, 191, leading question cannot be asked in examination, chief examination, both 1 and 3. So 4 is the answer. They generally be asked in cross examination, section 143. Next, 192, test identification parade pertains to the field of investigation. Next, 196, A rings up the police station and informed duty officer that he has murdered his wife because she was not preparing food for him. The information was duly recorded by the duty officer at a trial of having been committed the offence of murder. The statement made by A would be admissible होगी in evidence because the statement was made A was not in custody. Admissible only to the extent that A was the informant. Admissible to the extent that A was the informant and was present at his house and had knowledge of his wife having been murdered. So answer would be 2. Only to the extent that A was the informant.
Come to question number 26. Which of the following is correct statement? Evidence excluded by the Evidence Act is inadmissible even if it seems essential for ascertainment of the truth. Parties cannot contract themselves out of the provisions of the Evidence Act, both 1 and 2 or neither 1 and 2. It is both first and second statements are true. Question number 27. Which of the following qualities to be treated as a fact within the meaning assigned to it under Evidence Act? That a man heard or saw something, that a man holds a certain opinion, that a man acts in good faith, or all of the above. Fact, section 3 of Evidence Act. Right answer is option number 4, all of the above. Come to question number 28. According to the Evidence Act, a fact is said to be not proved when the court believes that the fact does not exist, or the fact is vague, or the fact is neither proved nor disapproved, or option 4, all of the above. This is also from section 3, and the right answer will be fact is neither proved nor disproved. Come to question number 29. A prosecutes B for adultery with C. Wife of A. B contested by denying the allegation. B was found guilty and convicted in the said case. Subsequently, C was prosecuted on the charge of bigamy on the allegation that she had married B during the subsistence of her marriage with A. C contested by denying that she was married to A. In the case against C, the judgment in the first case against B is relevant, irrelevant, binding, or none of the above. It is basically irrelevant. It is section 43, illustration B of Indian Evidence Act. Come to question number 30. Mark the incorrect statement. A court may take the assistance of expert for forming opinion on the point of foreign law, art, both 1 and 2 or neither 1 and 2. Expert opinion. It is section 45 of Evidence Act, and right answer is both 1 and 2, foreign law as well as art. Come to next question, question number 31. Which of the statements given below are correct? In civil cases, the character to prove the conduct imputed to a party is not relevant. The first option is basically what? It is related to section 52 of Evidence Act. Option 2, in criminal proceedings, bad character of accused is not relevant unless the evidence of good character has been given. And this one is section 53. And option 3, in criminal proceedings, previous conviction of accused is relevant as a evidence of bad character, 54. So the right answer here is all of these. Come to question number 32. A is on trial for murder of C. There is evidence to show that C was murdered by A and B, and that B said A and I murder C as against A. The evidence is option 1, not to be taken into consideration as the evidence is hearsay. Option 2, to be taken into consideration as it is direct. Option 3, not to be taken into consideration as A and B are not being jointly tried. Option 4, to be taken into consideration as A and B are accomplices. It is what? Option number 3, and this is illustration B of section 30 of Evidence Act. Come to question number 33. The essential conditions for dying declaration. Dying declaration is in which section? Section 32 of Indian Evidence Act. To be relevant include the statement is made by the person as to the cause of his death, statement is made by a person as to any of the circumstances of the transaction which resulted in his death. Option 3, the person must have been under expectation of death at the time of making the statement. Which of the above proposition are correct? The first option is correct and The second one is also correct, but the third one is not. Right answer is option number 1 and 2. Come to question number 34. Which of the following statements is correct? Confession caused by inducement, threat, or promise flowing from person in authority giving reasonable expression to the accused that he would thereby avoid punishment is relevant. It is what? Section 24. It is mentioned in section 24. Option 2. Confession by accused while in custody of police, even if made in the immediate presence of magistrate, shall not be proved. It is section 26. And the option 3, the confession of accused made in police custody may be proved if as a consequence of the information received as a relevant fact is discovered. It 27. So the right answer is what? Is none of the above. Come to question number 35. A is accused of receiving stolen goods knowing them to be stolen. He offers to prove that he refused to sell them below their value. Which of the following is correct? A may prove the statements though in the nature of admission because they are explanatory to conduct influenced by facts in issue. Option 2, A may not prove the statements because they are self-serving admissions. Option 3, A may not prove the statements because as accused he cannot be a witness in his own defense. Option 4, all of these are incorrect. Here the right answer is what? Option number first. It is mentioned in section 21. And it is basically illustration D of section 21. And what does section 21 talks about? It talks about the proof of admission against persons making them. Come to question number 36. Which of the following is incorrect under the Evidence Act? Option 1. In a case where A is charged with receiving a particular stolen wristwatch knowing the same to be stolen, the fact that at the same time he was in possession of other such stolen articles is relevant. Option 2. In a case where A is tried for the murder of B by intentionally shooting him to death, the fact that A was in a habit of shooting at people with the intent to murder them is relevant. This one, the option number 2, is basically illustration O of section 14, which talks about facts showing existence of state of mind or of bodily feeling. So incorrect statement is option number 2 only. Come to question number 37. C is employed as a cashier by a firm to receive money as is a sale counter. It is his duty to make entries in the ledger showing the amounts received by him. He is prosecuted on the charge of criminal breach of trust in respect of rupees 90,000 on the basis of evidence showing he made an entry showing that he had received rupees 10,000 only, whereas he had actually received rupees 1 lakh. C has taken the plea that the wrong entry was accidental and unintentional. The fact that other entries made in the same ledger are false, each showing a receipt of less amount by C, is relevant as it has a bearing on the question of intention. Option 2, not relevant as other entries are not basis of charge. Option 3, not relevant as evidence is extraneous. Or option 4, not relevant as other entries are not in issue. What is this? It is option 1, relevant as it has a bearing on the question of intention. And this one is basically illustration B of section 15 of Evidence Act. Come to question number 38. Mark which is not a public document within the meaning of the expression used in the Evidence Act. The records of motor accident claims tribunal. This one is public document. Option 2, the register of private documents maintained in the office of sub-registrar under Registration Act. This one is also a public document. Option 3, the record of proceedings of the House of People maintained in Lok Sabha Secretariat. And option 4, pronote executed by A while taking a loan from money lender. This one is not a public document. Option number 4 is the right answer, and it is a section 74 of Evidence Act. Come to question number 39. Which of the following is correct? There is a presumption that maps of various states and union territories made by the Survey of India are accurate. There is a presumption that map prepared by a registered architect for the purpose of a civil dispute is accurate. Both option 1 and 2 and neither option 1 and 2. It is section 83 of Evidence Act. And the right answer is option number 1. It is basically a presumption. Question number 40. The evidence of contents of information recorded or stored in a computer may be given through computer output without production of the original, provided certain conditions are satisfied. The said conditions include what? Option 1, if the computer was not operating properly during the material part of the period over which it was used to store or process. Option 2, the right answer here is both 1 and 2. Option 4, and this is section 65B of Evidence Act. Come to question number 41. In which case oral evidence cannot be given? Oral evidence, section 92. A hired lodgings of B and gives to B a card on which he wrote rooms rupees 2000 a month. A in a suit wants to prove verbal agreement that the terms included partial board. Option 2, A hired lodgings of B for a year. A regularly stamped. The agreement was drawn up by an attorney and signed by both of them. The document is silent on the subject of board. A in a suit wants to prove verbal agreement that the terms included partial board, both of 1 and 2 or neither 1 and 2. The right answer is here is option 2, and this one is illustration H of section 92. Come to question number 42. The burden of proving that the case of the accused comes within any of the general exceptions in IPC is upon whom? The prosecution, court, accused or investigating police officer. It is upon the accused, section 105 of Indian Evidence Act. Come to question number 43. The facts of which the court must take judicial notice include gazetted holidays observed by the government of India, rules of road, neither 1 and 2, and option 4, both 1 and 2. It is option 4, both 1 and 2, section 57 of Indian Evidence Act. Next question, question 44. Leading questions may be asked in examination in chief. Leading question in examination chief, section 142 of Evidence Act. With permission of the court as to the matters which are introductory. Option 2, if in the opinion of the court the matter involved has been already sufficiently proved. Option 3, neither 1 or nor 2. Option 4, both 1 and 2. It is both 1 and 2. Come to question number 45. For deciding whether or not a witness shall be compelled to answer questions, the court shall have regard to consideration which include as to whether such questions are: option 1, proper if the truth of imputation conveyed thereby would seriously affect the opinion of the court as to the credibility of the witness on the subject matter of his deposition. Option 2, improper if the truth of imputation conveyed thereby would affect in the slight degree the opinion of the court as to the credibility of the witness on the subject matter of his deposition. Option 3, both 1 and 2, or option 4, none of the above. This one is basically provisions contained in section 148, 1 and 2. So both these options are covered here. The right answer will be option number 3, both 1 and 2. Come to question number 46. Which of the following is correct? Rebuttable presumption arises that a man is alive if it is shown that he was alive within 30 years. Option 2, rebuttable presumption arises that a man is dead if it is proved that he has not been heard of 7 years by those who would naturally have heard from him if he had been alive. Both 1 and 2 or none of the above. Both these are section 107 and 108 of Evidence Act. The right answer here is option number 3. Come to question number 47. The court may presume that a document creating an obligation is in the hands of the obligator. The obligation has been discharged. Option 2, judicial and official acts have not been regularly performed. Option 3, bill of exchange accepted or endorsed was accepted or endorsed for deficient consideration. Or option 4, all of these are incorrect. See section 114 of Evidence Act, and according to that only first option is correct, and because the second one is, it is written that acts have not been regularly performed, whereas in illustration E they should have been regularly performed. Option 3 is related to illustration C, and here it is mentioned that deficient consideration, whereas in illustration C it is mentioned as good consideration. And first option is illustration I. The right answer here is option number 1 only. Come to question number 48. A intentionally and falsely led B to believe that a plot of land belonged to him. On that basis, he induced B to buy and pay for it. Afterwards, the plot of land became the property of A. A brought a suit to set aside the sale in favor of B on the ground that at the time of sale he had no title. In such a suit, A may presume a want of the title at the time of sale. A cannot be allowed to prove want of his title. Option 3 depends upon the value of the property, or all of these are incorrect. It is option 2. A cannot be allowed to prove the want of his title, and this is related to what? Estoppel. Which section? Section 115 of Evidence Act, and this is basically its illustration of this section. Come to question number 49. All persons are competent to testify unless the court considers that they are prevented from understanding the questions put to them because of tender age, correct, extreme old age, mental disease, all of the above. Right answer is all of the above, and it is related to section 118 of Evidence Act, which is who may testify. Come to question number 50. The judge's power to put questions or order production of documents does not include authorization to option 1 compel a witness to answer any question which such a witness is entitled to refuse to answer if the question is asked by adverse party. The option 1 is the correct answer, and it is in section 165, which talks about judge's power to put questions. Come to question number 154. Which of the following is a primary evidence? Primary evidences are mentioned where? Under section 62 of Indian Evidence Act. Now come to the options. Copies made from and compared with the original counterpart of the document as against the parties who did not execute them, counterpart of a document as against the parties who executed it, or certified copies of a document. So the right answer is option number 3, counterpart of a document as against the parties who executed it. See section 63, subsection 3, 4 and 1. These all are secondary evidences. So what is left? Option number 3 is left, that counterpart of document as against the parties who executed it. So right answer is option number 3. It is basically primary evidence, and it is given in under explanation 1 of section 62. Come to question number 156. Statement of a person who is dead and cannot be found is not relevant when it is made in course of business, when it is in favor of the interest of the maker, when it relates to the circumstances of the transaction resulting in his death, when it relates to existence of relationships. It is with section 32 of Indian Evidence Act, and the right answer will be option number 2, when it is in the favor of the interest of the maker. And what is section 32 of Indian Evidence Act? It says that cases in which the statement of relevant fact by a person who is dead or cannot be found is relevant. And if you see, it's point number 3, that or against interest of maker. So it is mentioned under section 32 subsection 3. Come to next question 179. Estoppel. Option 1 is a cause of action in itself creates a cause of action. Both 1 and 2 are correct, or neither is correct. It is neither is correct. Estoppel is basically what? It is a general principle. It does not create any cause of action. Come to question number 187. Both husband and wife are competent for and against each other in civil proceedings, in criminal proceedings, in both civil and criminal, or neither nor criminal, in actually both civil and criminal. And it is basically section 120 of Indian Evidence Act. Come to question number 195. Under which provision of Indian Evidence Act is expert opinion relevant? Expert opinion is relevant under section 45. And what is 41? It is relevancy of certain judgments in probate, etc. And what is 43? It is judgment not mentioned in 242. And 44 is what? Fraud or collusion in obtaining.
Next is 20. Secondary evidence cannot be led when original is in possession of other party. दे सकते हैं फिर तो. When original is of nature that it is not easily movable, तभी दे सकते हैं. When original is in possession of person who is out of reach, not subject to process of the court, तभी दे सकते हैं. तो ये तीनों कहाँ पर लिखे हुए हैं? सेक्शन 65 में. When original is in possession of person who wants to adduce secondary evidence, भाई उसी के possession में है और वही secondary evidence देना चाह रहा है, तो क्या हो पाएगा? No. 4 is the answer. Next 37. Where A is accused of an offense of rape and murder of a girl child, which of the test can A be subjected to without his consent for the purpose of investigation? None of the above. Without his consent, cannot do any of these tests. 4 is the answer. Next is 38. Which of the following statement is incorrect with regard to TIP, test identification parade? It constitutes substantive evidence. No, it is not only corroborative evidence. So 1 is the answer. And where it is mentioned TIP कहाँ करते हैं, कहाँ रेलिवेंसी है इसकी? सेक्शन 9 ऑफ इंडियन एविडेंस एक्ट में. Next is 42. B is found dead having suffered injuries with sharp weapon. A, while in police custody, confessed to killing B and with the motive of stealing his motorcycle after following him from his office and having concealed the weapon of offense, that is a knife, on his rooftop. A gets the knife recovered from the police. In this case, section 27 of the following would be admissible. क्या admissible होगा इसमें? The place from which the knife was produced and the knowledge of A leading to recovery of knife. 2 is the answer. What is 27? So much of such information which leads to discovery of a thing at a distinct place, only that information is relevant. Next is 44. Which provision of Indian Evidence Act embody the concept of registry? It is mentioned in section 6 and some in section 8. 6 तो है ही है, 8 में भी है. And what is in section 8? It is preparation, conduct and motive. Next is 53. B has robbed and murdered. Soon after stolen goods were found with A. In these circumstances, what may not be presumed? The court may presume that A committed the robbery of B but not his murder, committed murder of B but not robbery, committed both robbery and murder. Mere recovery of stolen article from A would not justify the court is presuming that A committed either the robbery or murder of B. Court may presume that A committed both robbery and murder. So 3 is the answer. Where it is mentioned? It is mentioned in section 114 of Indian Evidence Act, illustration A. Next is 63. A filed an FIR giving detail of a crime that he had committed. There were no exculpatory statement in the FIR and gave all the details regarding the commission of crime. Which of the following statement is accurate? The FIR is hit by section 25 of Indian Evidence Act, hence inadmissible as evidence. However, the fact that A filed an FIR is admissible under section 8. Answer would be 1 only. देखिए second option जो है, since the FIR confessional in nature, FIR is not admissible. FIR confession is admissible, was voluntary before arrest, admissible under 32(3). इसका आंसर रहेगा 1. Next is 64. The previous sexual experience of a prosecutrix in a case of rape where the question of consent is an issue can be used to impeach the creditworthiness. No, not allowed. It is irrelevant. Mentioned in section 146 proviso, amended by 2013 Amendment Act. Next is 65. Which of the following person is not entitled to maintenance under section 125 from a man who has sufficient means and refuses to maintain them? देखिए यहाँ तक भी अगर लिखते हैं ना 125, तब भी हम समझ जाते हैं कि हाँ भाई मेंटेनेंस तो मांगेगा, तो किससे मांगेगा? जिसके पास सफिशिएंट मीन्स हो. बट यहाँ पर सिर्फ टाइम खराब करने के लिए इतना लिखा हुआ है. अब पूरा पढ़ना ही पड़ता है, छोड़ भी नहीं सकते. तो वो है डॉटर इन लॉ. 3 इज द आंसर. दे कैन आस्क मेंटेनेंस नॉट अंडर 125 बट अंडर हिंदू अडॉप्शन एंड मेंटेनेंस एक्ट. Next is 109. Autopsy report provided by medical examiner is eyewitness evidence, opinion, contradictory. It is only an opinion. So 2 is the answer. Next is 111. Primary evidence means and includes the original document. Oral है, true copy देखने की जरूरत ही नहीं है. Whereas primary evidence is mentioned in section 62. 61 क्या कहता है? Proof of contents can be primary or secondary. 62 कहता है primary evidence. Next is 112. Under 33 of Evidence Act, evidence of witness A recorded in an earlier judicial proceedings can be produced in another judicial proceedings where witness A is alive and incapable of giving evidence. Under section 32 का 3. Next is 116. Principle against hearsay applies. किस पे apply होता है? Only to oral evidence and not to documentary. Only to documentary, not to oral. Both oral, documentary, neither. तो hearsay कहाँ होता है? Both oral and documentary evidences पर. This is also a general principle of law. Next is 117. Bar of exclusion of oral evidence by documentary evidence under section 91-92 applies. कब apply होगा? When the fact to be proved would invalidate document, shows in what manner language of document was related to existing fact, when the fact relates to want or failure of consideration, relates to terms of a contract reduced in form of document. So 4 would be the answer. Section 91-92 talks about the terms of contract which reduce in form of document. Next, 118. A tenant of an immovable property can deny title of landlord to such immovable property only when tenancy is expired, मतलब not during the tenancy, he cannot deny the title, and it is mentioned where in section 116 of Indian Evidence Act. Next is 119, a person suffering from schizophrenia, one क्या है, is competent to testify, can testify when he can communicate verbally, can understand question and answer them rationally. So 3 would be the answer. Through his father, no. Next is 120, handwriting of A on document B can be proved by the digital signature of A. A person who claimed to receive document B purport to have been signed and written by A. Person who in ordinary course of business has habitually received document purported to have been written by A. Person who stated that he is a friend of A. Answer would be 3. And where it is mentioned, section 47 explanation talks about that. Next is 121. Under section 57 of Indian Evidence Act, a court cannot take judicial notice of what? Rule of law, land, sea, matters public history, uncontroversial notorious facts, newspaper reports. तो इसका आंसर क्या होगा? Newspaper reports. और देखिए अगर यहाँ लिखा होता है ना controversial, तो ये इसमें भी आ जाता, cannot take.
Now let's come to the question number 1. A document claimed to be a will shall not be used as evidence until all the attesting witnesses have been called for the purpose of proving its execution. Option 2. All the attesting witnesses alive and subject to the process of the court and capable of giving evidence have been called for the purpose of proving its execution. Option 3. One attesting witness at least has been called for the purpose of proving its execution, if there be an attesting witness alive and subject to the process of the court and capable of giving evidence. And option 4, it has been registered in accordance with the provision of Indian Registration Act 1908. Well, the correct answer is option number 3, and it is mentioned in section 68 of Indian Evidence Act, which talks about proof of execution of document required by law to be attested. Next is question number 2. An attested document not required by law to be attested has to be necessarily proved by examining an attesting witness, may be proved as if it was unattested, is inadmissible in evidence, can only be proved by examining the executant. Well, this one is section 72 of Evidence Act, and here the right answer will be option 2, may be proved as if it was unattested. And what does section 72 talks about? It talks about proof of document not required by law to be attested. Now come to question number 3. For leading secondary evidence, moving an application seeking permission, therefore, immediately after admission, denial of documents and before framing of issues is essential. Option 2, an application seeking permission of the court is to be filed before commencement of the evidence of the party seeking to lead secondary evidence. Option 3, no application seeking permission of the court is necessary. Option 4, application seeking permission, if not filed earlier, can be filed even after conclusion of the evidence. Well, this one is what? Section 65 of Evidence Act, secondary evidences, right? And according to that, right answer will be option number 3. No application seeking permission of the court is necessary for leading secondary evidence. Next is question number 4. In a suit to which the bank is not a party, the contents of the book of the bank can be proved by what? Right answer is option number 2. By tendering in evidence a copy of the said contents certified by the bank in terms of section 282A and 4 of the Bankers Book Evidence Act without compelling the presence as a witness of the officer of the bank. This one is actually a conceptual question, and some gist of it is mentioned in section 35 of Evidence Act plus section 5 of Bankers Book Evidence Act. And together with that, it is also mentioned in section 139 of Indian Evidence Act. It says that when a person is asked to produce a document, he does not become a witness and cannot be cross-examined, right? Okay, so according to that, the right answer is option number 2, and return of documents. Next is question number 7. The court may presume, option 1, that a document creating an obligation is in the hands of obligator, the obligation has been discharged. Option 2, that an accomplice is unworthy of credit unless he is corroborated in material particulars. Next is option 3, and option 4 is all of the above. Option 3 is long enough, so you can read it yourself. Well, the whole question is related to section number 114 of Indian Evidence Act, and these all the options are basically illustration of that section. For example, option number 1 is illustration I, and option number 2 is illustration B, and next one, option number 3 is basically illustration E, C, F, G, and H. So all these are illustrations. So right answer will be what? Option number 4, all of the above. Next is question number 8. The fact that any person was born during the continuance of a valid marriage between his mother and any man is a conclusive proof that he is the legitimate child of that man, is a conclusive proof that he is the legitimate child of that man, unless it is shown that the parties to the marriage had no access to each other at any time when the child could have been begotten. Well, the right answer is option number 2. And it is mentioned where? It is mentioned under section 112 of Indian Evidence Act. Legitimacy is mentioned where? Under section 16 of Hindu Marriage Act, which says that legitimacy of children of void and voidable marriage. Next one is question number 9 is estoppel. Estoppel is mentioned where? Section 115 of Indian Evidence Act. Options is an equitable principle, is a rule of common law, is a principle evolved by judicial pronouncement, or option 4 is codified in Indian law. Well, it is mentioned in section 115, so definitely it is a codified. So right answer is option number 4, it is codified in Indian law. Next is question number 10. A party to a suit can prove a fact in issue by examining one witness only in proof thereof. Option number 2, by examining not more than 3 witnesses in proof thereof. Option number 3, by examining any number of witnesses in proof thereof, unless the court is satisfied that the examination of any particular witness is not relevant and is intent to delay the trial. And option number 4, by examining any number of witnesses in proof thereof, and the court cannot limit the number of witnesses sought to be examined. The right answer is option number 3, and it is mentioned where? Section 134 of Indian Evidence Act. And section 34 talks about what? Number of witnesses. Next is question number 11. During the continuance of possession of immovable property, the person in possession is stopped from denying the title to such immovable property of the person who put him in such possession if the possession is as a tenant or is as a licensee. Option 3, the person is in possession is in unauthorized occupation, or option 4, both 1 and 2. Well, this question is related to section 116 of Indian Evidence Act, and it is mentioned there that the possession as a tenant and as well as licensee. The right answer becomes option number 4, both 1 and 2. Question first. Alibi is governed by Section 6 of Indian Evidence Act, or option 2, Section 8 of Evidence Act, Section 11 of Evidence Act, or Section 12 of Indian Evidence Act. So it is a very simple question. Alibi is governed by Section 11 of Indian Evidence Act. So right answer is option number 3. Okay. So what does the Section 11 says? It says that when facts not otherwise relevant becomes relevant. In other words, it is rule of alibi. Now, what does section 6 talks about? Section 6 talks about relevancy of fact forming part of same transaction. And what does section 8 talk about? Section 8 talk about motive, preparation and previous or subsequent conduct. Motive, preparation, previous or subsequent conduct. And what does section 12 of Indian Evidence Act talk about? In suits for damages, facts standing to enable court to determine amount are relevant if they are inconsistent with any fact in issue or relevant fact, or second, if by themselves or in connection with other facts they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. Now, question second. Communication without prejudice are protected by which section? Section 21 of Indian Evidence Act, or 22, or 23, or 24. So what does the section 21 says? Section 21 of Indian Evidence Act talks about proof of admissions against person making them and by or on their behalf. Okay, and section 22 is when oral admissions as to contents of documents are relevant. And section 23 is the right answer, that is communication without prejudice is protected by section 23. And what does the section 24 says? It says that confessions caused by inducement, threat or promise when irrelevant in criminal proceedings. So right answer is option number 3, section 23 of Indian Evidence Act. Question number 3. Under section 27 of Indian Evidence Act, the whole statement is admissible. Only the portion of the statement which leads to the discovery is admissible. Or third, both 1 and 2 are admissible, or option 4, none of the above are admissible. So section 27 of Indian Evidence Act talks about how much of the information received from the accused may be proved. The right answer is option number 2. Only the portion of the statement which leads to the discovery is admissible. Information given by the accused person to police officer leading to discovery of a fact which may or may not prove incriminatory has been made admissible under section 27 of Indian Evidence Act. Okay, and section 27 also provides that confessional statement made to the police officer or while an accused is in police custody can be proved against him if the same leads to discovery of the unknown fact. Now question number 4. A dying declaration to be admissible must be made to whom? Magistrate, doctor, police officer or all of the above. The right answer is option number 4, all of these, and where it is mentioned under section 32, comment section 3 okay, of Indian Evidence Act. Now question number 5. The opinion of an expert is relevant under which section? Section 45, 46, 47 or 48? It is relevant under section 45 of Indian Evidence Act. The right answer is option number 1. And what is in section 46, 47 and 48? Section 46, it talks about the facts bearing upon the opinions of the experts, and 47 talks about the opinion as to handwriting when relevant, and section 48 talks about opinion as to existence of right or custom or when relevant. Now question number 7. Legal advisor can disclose the professional communication after the death of his client, or can disclose the professional communication after the relationship with the client has ended, can disclose professional communication if made in furtherance of any illegal purpose, or option 4, can disclose the professional communication in all the above instances. The right answer for this is option number C, can disclose the professional communication if made in furtherance of any illegal purpose. Here section 126 talks about professional communication, and this is mentioned in its proviso that any illegal purpose or an effect observed by any barrister, pleader, attorney or vakil in the course of his employment as such showing that any crime or fraud has been committed since the commencement of his employment. Okay, these two are the reasons when the legal advisor can disclose the professional communication made with his client. Now question number 8. Power of the court to suo motu examine any person at any stage is under which section? Section 163, 164, 165 or 167? The right answer here is section 165 of Indian Evidence Act. And what does the other section talks about? Section 163 of Indian Evidence Act says that giving as evidence of any document called for or produced on notice, and section 164 is using as evidence of any document production of which was refused on notice, and 167 is no new trial for improper admission or rejection of the evidence. Right answer is here section 165. Now question number 9. Under section 116 of Indian Evidence Act, the tenant is stopped from denying the title of landlord during the continuance of tenancy, before the creation of tenancy, after surrender of possession, or all of the above. Here the right answer is option number 1st, during the continuance of tenancy, and it is mentioned under section here 116, which says that estoppel of tenants and of license of person in possession. No tenant of any immovable property or person claiming through such tenant shall, during the continuance of his tenancy, be permitted to deny that the landlord of such tenant had at the beginning of tenancy a title to such immovable property. Now question number 10. A fact under Section 3 of Indian Evidence Act means and includes anything capable of being perceived by senses. Option 2, state of things capable of being perceived by senses. Option 3, relation of things capable of being perceived by senses. Or option 4, all of the above. The right answer here is option 4, all of the above, because Section 3 of Indian Evidence Act says that fact means and includes anything, state of things or relation of things capable of being perceived by the senses, or any mental condition of which any person is conscious. Right? Now come to question number 11. An accomplice is a competent witness under which section? Section 118, 119, 132 or 133 of Indian Evidence Act. It is a question from chapter 9 of Indian Evidence Act, which talks about witnesses. Accomplice comes under which section? Section number 133 of Indian Evidence Act. Right answer is option number 4, 133. And what does the other section talks about? Section 118 talks about who may testify. Okay, 119 talks about witness unable to communicate verbally. Now 132 talks about witness not excused from answering on the ground that answer will criminate.
सो फ्रेंड्स, यहाँ पर हमने इंडियन एविडेंस एक्ट के सभी क्वेश्चंस को डिस्कस कर लिया है. अगर आपको इसमें कोई प्रॉब्लम लगी हो, कोई सजेशंस हो, कोई कमेंट्स हो, तो आप कमेंट सेक्शन में जाकर भी लिख सकते हैं. एंड अगर आपको वीडियो अच्छी लगी, इसको ज़रूर लाइक कीजिएगा, शेयर कीजिएगा एंड सब्सक्राइब करना ना भूलिएगा. एंड अपने फ्रेंड्स को भी बताएं कि उन्हें यहाँ पर सारे क्वेश्चन जो अभी तक आए हुए हैं सब्जेक्ट वाइज मिल जाएंगे. सो फ्रेंड्स, थैंक्स वेरी मच फॉर वॉचिंग दिस वीडियो. थैंक यू.